Welcome to Chapter 4 of Essentials of Healthcare Finance, the Legal and Regulatory Environment of Healthcare. Healthcare providers are responsible for complying with a myriad of laws and regulations addressing patient billing, cost reporting, physician transactions, occupational health and safety, and fair labor standards, and more. Allegations of violations of laws and regulations are widespread. Consequently, federal and state government interest in combating fraudulent and abusive practices is also now widespread. High-profile settlements involving many types of providers and settlements into the hundreds of millions of dollars have provided additional incentives for the government to continue its scrutiny of the healthcare industry. It is incumbent on today's financial manager to have an understanding of the risks that non-compliance can pose. This chapter covers the major areas of federal rules and regulations that affect the delivery of healthcare services. Some of the major topics covered are fraud and abuse, antitrust, Stark laws, QTEM actions, the FCA, the Emergency Medical Transfer and Active Labor Act, or referred to as EMTALA, HIPAA, and corporate compliance programs. The learning objectives for this chapter are to understand how legal and regulatory issues shape and define good financial management of a healthcare organization, and 2, appreciate the consequences of failing to manage the finances of a healthcare organization with regard for the complex and ever-changing array of laws and regulations that are unique to this industry. 3. Recognize when and how to involve legal counsel on a Medicare or Medicaid reimbursement issue or other financial matter that has a regulatory compliance implication or would otherwise require you to seek legal advice before making a decision. 4. Identify the most common federal regulatory issues such as fraud and abuse, Stark, HIPAA, privacy and security, EMTALA, and IRS requirements for tax-exempt organizations, as well as less common concerns that arise under the antitrust laws, red flag rules, and state insurance regulations. 5. Identify the major components of a corporate compliance plan, including the establishment of internal controls relating to the finances of an organization. 6. Be prepared to respond to a compliance audit or investigation, particularly when the subject of that inquiry includes financial records. 7. Be aware of the most important aspects of the Patient Protection and Affordable Care Act of 2010, the Health Reform Act, as it relates to financial management in the post-reform environment. When developing a corporate compliance plan, the Office of Inspector General lists the requirements for such a plan. And they typically have internal controls and corporate compliance plans as well. Primary regulatory issues related to Medicare reimbursement affect all parts, Part A through D, the certification of providers, and the payment to providers. For Medicaid reimbursement is eligibility determination at the federal poverty level and supplemental Social Security income, what services are covered, and the established payment rates and the Medicaid Department of State Health Service payments. So beneficiaries have 5 levels of Medicare appeals in their process. And then under fraud and abuse are the False Claims Act, QTEM actions, and kickbacks and self-referrals, such as anti-kickback statute issues and Stark physician self-referral laws. So the QTEM is a provision in the federal FCA that allows persons and entities with evidence of fraud against federal programs or contracts to sue the wrongdoer on behalf of the government. And the Stark laws, or the kickback statutes, prohibit physician referrals to entities in which the physician has a financial relationship. So there are 10 specific designated health services for which referrals by physicians who have financial relationships with entities providing these designated health services are prohibited. There'd be clinical labs, physical and occupational therapy and speech language pathology services, radiology and certain other imaging services, radiation therapy, durable medical equipment, parenteral and enteral nutrients, equipment and supplies, prosthetics, orthotics, and prosthetic devices and supplies, home health services, outpatient prescription drugs, and inpatient and outpatient health hospital services. The False Claims Act itself has 5 elements that pertain to the establishment of a false claim. 1 is the claim. 2 is it's submitted to the U.S. government. 3, which is false or fraudulent, if a claim is submitted that is false or fraudulent, with sufficient knowledge by the defendant of the falsity of the claim and constitutes a negative and direct effect on the federal treasury. Those are issues of False Claims Act. The HIPAA privacy rule became effective on April 14th in 2001. Most health plans and healthcare providers that are covered by the new rule comply with the new requirements. The privacy rule for the first time created national standards to protect individuals' medical records and other personal health information. The HIPAA privacy standards were designed to accomplish 3 broad objectives: define and limit the circumstances in which entities that are subject to the standards, covered entities, may use and disclose protected health information, establish certain individual rights regarding protected health information, and require covered entities to adopt administrative safeguards to protect the confidentiality and privacy of protected health information. Some antitrust issues are what prompt the purpose of laws related to antitrust to promote a competitive free marketplace. We have one such as the Sherman Act to ensure that agreements do not exist that unreasonably restrain trade or engage in price fixing. The Clayton Act prohibits mergers and acquisitions that may substantially lessen competition. There's analytical methodology that's provided. Will the merger increase concentration in the market? Does increased concentration raise anti-competitive concerns? Can another competitor enter the market? Are there efficiencies to be realized? Without the merger, would either of the merging parties fail? EMTALA is the federal law prohibiting medically unjustified patient transfers. Areas covered include required reporting of violations by other hospitals, acceptance of transfers by specialized facilities, ambulances, and exclusion of violating physicians from Medicare. In short, it prohibits hospitals from transferring an emergency patient because of an inability to pay. So in summary, healthcare financial managers need to have some understanding of the major rules and regulations related to healthcare. The legal and regulatory environment in healthcare is increasingly complex. A prudent manager must plan for and adapt to this environment. Failure to comply can put the organization at significant financial risk and can put individuals at both criminal and financial risk. Proper planning, implementation, execution, documentation, and evaluation of corporate compliance programs is vital for the financial security of today's healthcare organizations.